Did you just get out of jail?
Yes, sir.
When? Okay, you didn't just get out of jail. When you come to court, come dressed appropriately. Shorts is not appropriate for court. It's a complete sign of disrespect. You understand? Okay, if you do it again, I'm going to put you out. You're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right?
Yes, Judge. On February 3rd, 2025, at approximately 11:53 p.m., the officer observed a vehicle on a public road with a defective front left headlamp, and the officer ran a check on the vehicle and it returned with unconfirmed insurance. A traffic stop was initiated, and the defendant quickly exited the vehicle, and the officer gave multiple commands for him to get back inside and shut the door. The defendant stated he wasn't going to, and the officer had no reason to pull him over. The defendant then walked back and got inside the vehicle, but held his feet outside the car and did not shut the door. From the officer's trained experience, he has seen situations where the driver would sit like that, then leap from the car and try to hurt officers, and the defendant put his feet into the car and the officer approached. The vehicle had 2 young children, but not a car seat, standing in the front passenger seat, and the officer asked the defendant several times for his name, and the defendant stated he could not because the officer was fucking with him. The officer informed the defendant of the legitimate reason for the traffic stop, and the defendant continued to refuse to provide his name. The officer asked the defendant to exit the vehicle, and the defendant then refused. The officer went to grab the defendant's wrist, and the defendant pulled away from the officer and other deputies. The deputies advised the defendant that he was going to be tased, and the defendant exited the vehicle. The defendant stated he wasn't going in handcuffs and resisted by tensing his arms and body and concealing his hands towards his front waistband. The defendant was taken to the ground where he continued to resist. After several commands, the defendant was going to be tased. The defendant finally put his hands behind his back.
All right, Mr. Collier, I'm going to find that there's probable cause to go forward with your case. Can you run his license to see if he has a valid Texas driver license?
I'll run it right now, Your Honor. It's eligible, Your Honor.
Mr. Collier, I'm going to find that there's probable cause to go forward with your case. I'm not putting any conditions on your bond. Just be careful. You get into a pissing match with people who have the power of arrest. Who's going to win? You know what I mean?
Sir.
Just, it's a logical conclusion. That's all it is. Just be careful when you're out there. Life's hard enough. As an African-American in today's society, don't make it any harder, you know?
Sir.
Do you want to apply for an appointed lawyer?
Sir.
All right, I'm going to give you an application. I'll have you sign and reset with Billy. I'm not putting any conditions on your bond. Just be careful. That's it. All right? Come on, man.
Rory Johnson.
Hold on, Billy, because I think Mr. Holt is, are you ready?
Yes,
All right, come on. So you have Mr. Blanco.
Yes, Your Honor.
Hugo Blanco, come up. Good morning, Mr. Blanco. Sir, you're charged with terroristic threat on a public servant. That elevates it to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
It's Judge. On February 3rd, 2024, the officer was dispatched to Eastside Transportation and made contact with the complainant, a bus driver. The complainant explained that she made an exception to her usual route to drop off a student closer to home. When the complainant was halfway to the student's home, she opened the doors to let the student off, and the defendant approached the bus doors and appeared to grip an area where his firearm was located at his hip. The defendant asked the complainant if she planned to write up his daughter, and the complainant said yes. The defendant then took a few steps back and lifted his shirt to expose his firearm while making threatening statements. The complainant was in fear for her life and did not want to come back to work, and the officer confirmed the incident by bus camera footage. And specifically, the defendant lifted his shirt to expose his firearm while continuing to make threatening statements, telling the complainant, "I got you." And then seeing the firearm, the complainant quickly closed the bus doors to leave, and as they were closing, the defendant lifted his shirt again to display the firearm, still repeating, "I got you."
Mr. Blanco, I'm going to find that there's probable cause to go forward with the case. Look, I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? As long as you can abide by these conditions, you and I will be fine. If I find that you pick up a new case, you have any kind of weapons, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Now you have a lawyer. Good job on having a lawyer. Because you have one, I will waive your appearance, but it is your responsibility to stay in touch with him, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're, ducking and dodging and playing games, I will issue a warrant for your arrest. I'm not asking much. I just want my public to be safe. You understand? All right. So I'm going to have you sign a receipt with Billy. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right. You found no weapons, please. And then no contact. Yeah, please. Ready?
Rory Johnson, step up, please.
Coming up, Mr. Johnson. Right here. Mr. Johnson, you were charged with evading arrest and detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present and be cannot afford one. One will be appointed to you, sir.
Yes, Judge. On February 3rd, 2025, the officer observed a vehicle with no proof of financial responsibility. The officer also observed the registered owner of the vehicle to have an open warrant out of Harris County. The vehicle ran a red light and stopped past the designated stopping point, and the vehicle turned north, driving quickly as to elude the officer's patrol vehicle. The defendant pulled into a driveway. The defendant got out of the driver's seat as the officer attempted to initiate a traffic stop with emergency equipment for the traffic violations and conduct the investigation. The officer told the defendant to come to him, and the defendant began to evade on foot. The officer told the defendant to stop, but the defendant continued running, jumping over fences before he was taken into custody. The defendant evaded for approximately 100 to 200 yards and was identified based on his ID and name.
What was the basis of the stop again?
So no proof of financial responsibility and running a red light.
Got it. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with the case. I'm telling you now, you're extremely lucky that this is a misdemeanor. This is your third. On a second, it's a felony offense. You're very lucky. Can you run his license, please?
It's ineligible, not eligible, Your Honor.
Have you signed an affidavit with me today, Mr. Johnson? I don't care what's going on in your life. Do not drive. Do you understand? This is an affidavit that you're going to be promising me you're not going to drive. If you want to drive, go get a license, get liability insurance, and I will take this restriction off. But if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Do you have the ability to hire a lawyer, Mr. Johnson? So I'll have you fill out an application. I'll take a look at it to see whether you qualify. I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Billy to sign a receipt, and then we'll take a look, fill it out. Don't pick up any new cases. Do you understand? You are lucky that this is not a felony offense right now as it is. So you have any THAs? Do you know? Hey,
Firearm, may I approach?
what's up?
I was just in the neighborhood, so I thought I don't know if this is something we can do without my client, but I wanted to just check it out. I've got a young kid who's in high school, living at his parents' house. He's on house arrest with a laundry list.
I remember the one kid.
He needs to take his SAT test to try to get into college. That is March the 8th. I just wanted to approach and make sure
Okay with that.
you're kosher. Okay, much
Yeah,
obliged. Thank you.
Absolutely. Let them know. And for the time that he needs to go out, we're okay with it.
I know everybody wants to go take the SATs. Thank you, Judge.
Have to.
We did. We've all paid our dues. Thank you, Judge.
Absolutely. Marcos, you ready?
I'm waiting on
Not yet.
just to make sure we're ready to go.
Not yet, Your Honor, the paperwork's not ready.
Do you have a plea, Marcos?
Yes, Judge.
The flag here?
Who's it?
Yes.
Who is it on?
One more, Chief.
Oh, is it the gentleman from the back?
He's
Oh,
right
he's
there.
out. Okay.
He's.
Did we do a TRAS?
Yes, so he's been in custody now. Bottom line, Judge, the offer is 21 days. Credit for 7.
I don't know if I'm going to take a time served on someone who's got an open DWI in another county and he's got a DWI here and he's got.
It's not open over there, Judge. He's not open. It's not open over there. He's not open over there. And he told me he's reporting once a week to some sort of a treatment over there. It's the 22-month probation in Tarrant County. And he lives in Tarrant County. His family's in Tarrant County.
Signature.
Thank you, Judge.
So it's 22 months over there. His family's over there. He has to report. He was just telling me once a week to, I don't know exactly what it is. I'm thinking some sort of treatment. And for him to come down here constantly is just, it's not feasible for him. So that's why I thought, you know what, let's just close him out. Yes, he'll have 2 convictions, but he'll be in Tarrant County. He'll take care of that. He'll get, help over there, and then he'll be done.
Said he has how much credit?
He should have 7 days.
We did do a TRAS though, right?
Yes.
What did the TRAS recommend? I'm assuming residential?
Community, not, oh, I guess that's different then.
Followed by IOP SSC, because they took into consideration because of the year immigration status and all of that. Because he was very self-employed and he didn't qualify.
Because of the immigration issue? Or
Because
what?
he lived in Tarrant County as well.
Hmm.
A community residential is what they came up with.
I don't know, Marcos. Every time we deviate from that, it explodes. It literally just,
What if I find out? What if we reset him so I can get more information from Tarrant County? And talk to his probation officer and figure out exactly what he's going to be doing over there. And then if it's similar to this and he's getting the treatment, then
but this is residential. They're not doing this. Otherwise, he would be in it right now. I doubt that because they already pled him, right? I don't even know if they knew that this thing was open. So they're just,
sure they did.
I mean, I don't know. I mean, we can't speculate on things, right? Because it's just. Thanks.
Mr. Butler. Mr. Butler.
Thank you.
All right. I mean, whose next one's a felony? I mean, they'll have to deal with that, I guess. All right.
Understand.
Okay, Mark.
Bring him up.
You ready?
I need to come.
Oh, sorry. Yes.
Did you read his motion to suppress?
I did. I'm sure Mackenzie did.
I was working in, oh, that.
I'm starting here.
Yeah, so.
Mr. Martinez, let me tell you, you scare me. It's individuals like you that just don't get it, how dangerous DWIs truly are because you continue to do what you're doing. And you may truly have a problem. I hope that you don't dig yourself such a hole that you will never get out of. But that's what DWIs are. Invariably, if it continues, at some point, you may eventually kill someone. It's not fair. Don't. If you're going to drink, if you're going to get lit, if you're going to have 32 beers, stay the flip home. If you have to go out, take an Uber. Is it so hard? All you have to do is push one button on your phone and someone will take you home. With all the baggage that you have on your record now, if you ever get pulled over and an officer smells even one smidgen of alcohol, they're going to take you in. And from now on, you were looking at a felony offense of 2 to 10 in the penitentiary. So if you don't get it now, perhaps prison is what you need. You're young. You're going to be driving for the next 30 years. Get a clue. Do you understand?
Yes, Your Honor.
Yes, Your Honor.
The only reason I'm doing this now is because you're on probation for the next 2 years in another county. Otherwise, this would not be happening now. Take note and try to better yourself. It's not hard. All we're asking you to do is don't kill someone. Don't get into a car. You're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 21 days in jail with credit for the 7 days that you've done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. It's going to be there for the rest of your life. Somehow I have to get through to you. What I'm going to do to you now is you will be required to pay the DPS fines and fees of around $4,500. And if you don't pay it, every $100 you owe, you will sit 1 day in jail. Do you understand? I am also suspending your ability to drive for a year. Do not get into a car. If I see you back in here, it's really not going to go well. Do you understand?
Yes, yes.
I'm not asking for much. If you have a problem with alcohol, address it. That's all I'm asking to do. I'm literally, don't kill someone. How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
Is it true or untrue that you had a .15 or above? Okay, true to the enhancement. All right, Mr. Martinez, make us proud. That's all we're asking you to do. All right, let's see the clerk.
Thank you, Judge.
Thank you.
May I excuse me?
Yeah. 2-year payment plan. Did you read this motion to suppress? Read it. It's interesting. Yeah. Take a look at it. Both you guys. Tell me what you think. Well, I guess let's wait.
Your name, Rory Johnson? Something from the only commissioners, Johnson, just don't have that's your name? Is he right here? Let's see.
Hi.
Yeah, good morning. Raquel Williams. It's a DWI. We just need to get medical records released. They're gonna file the motion. I just wanted to approach to see if we can make note of it. It can be done in the meantime instead of when we come back for that release.
You mean,
There's,
have medical records ready to give to them?
Yes, and we just need to file the motion.
Okay, so go ahead, file it. I'll sign it. As soon as you file it, I'll sign it. So it's old though. It's 184 days old. Do you have an offer?
we're supposed to be trying to get PTI on it. She did a TRAS, the last.
So first apply. Don't just get the TRAS because, there's a lot of changes that have been made. So I've seen more denials now. So,
She's already done the TRAS.
oh, she's already done it.
Yeah, I had her
So
do it when she was here last time because her appearance had been waived, so
Tell me, is blood test?
it should be blood from, it was a hospital visit, so, yeah, there was blood. It was like a point one.
What is it? What are the results?
7, I believe.
Results?
It's a point 1 7.
I'm curious to see whether she's approved or if she needs a medication packet.
It was 10125.
What is it?
125.
Okay, okay, so it's not.
I do have, mitigation. I need to scan everything and send it over. I got, it
Accident?
was an accident.
Accident.
She ran into the back of a tow vehicle,
I think that you're
but still an accident.
still gonna need it.
Right.
Like this, they're gonna want insurance and all that stuff.
Right.
How much time do you want?
I can't hear you, Judge.
Shh. How much time do you want?
I don't, a couple weeks is fine with me. I don't need.
So
I'll be able
what
to
I would,
get
so
But we'll
can you
submit.
get the records to her today? Please file the motion. I'll sign it now. That way we're ready with that. And then in the interim, we'll give you 2 to 3 weeks
Okay.
But the next setting, if you can have everything turned in, and then that way we'll wait for a response, whether approved or denied. And I mean,
And then I have a question for you, Judge. Her license is valid now. And can she drive? She wanted me to ask for permission. Last time you told her to ask before doing anything. She's working, but Dad is taking her back and
I would
forth.
ask is just make sure that she has liability insurance, right? Make sure she has car insurance. If she has car insurance, then I'm okay
James
with
told
it.
me he
As long
put
as
her
the
on.
license is clear and she has insurance, I'm okay with it.
Just want to document it. It's fine.
Alicia, on Raquel Williams, we ordered no driving. Can you confirm with her now? Ms. Moore? All right, can you confirm with her now? Does she have insurance now?
Dad replaced her on, I confirmed with him. He was here last setting with her and they were ready to confirm it then.
So they have car insurance?
It's not, let me find out if he actually, because I told him that last time, judge is gonna want to know you have it already.
As long as she has car insurance, I'll amend the conditions to allow her to drive.
Okay.
Yeah. And then after that, if she does, let Felicia know. And then we'll amend the conditions to allow her to drive. And then just get a reset with Billy. And then, yeah. Mr. Butler, are you able to work it out or no?
Work out some of the.
Just the case in general or no?
So they agree that my issue is, good and valid on that first case. And we can talk more about it if you want to.
No, I get it.
Yes, sir. And we back that, I'll show you from the years if you would like. We can take you right through that second.
I don't think, and look, have you seen what he's talking about?
Yes, and I just spoke with,
And is it as in the motion, as they say, have you seen this?
That is a transcript. Judge.
the
Okay.
facts of the motion are as he said it's,
Word for word.
yes.
What do you think?
I actually just spoke to Alex and he said that case was recently overruled by,
It's just that the Erdman case was overruled by the Court of Appeals, the Criminal Court of Appeals in 2012 by a case.
No. This is Serrano.
They cites the Erdman case, the underlying,
You talking about Simon? It didn't overrule Erdman.
they state,
No, it didn't.
and I would like to, we can read it together. I would like to share it with the court. And
Last I checked, a court of appeals out of the Sixth Circuit or something does not overrule the court of criminal.
this is the Court of Criminal Appeals, Finan.
I'm sorry?
Finan is out of the Court of Criminal Appeals.
Okay, so tell me what it's. Let's hear this.
1 second. So. One.
Obviously, we'll give you time to look at it so you
Yeah,
can.
no, it's still up to you. I've read fine.
And I would like to share it with you. So it says the rules developed by Erdman's progeny are contrary to the fundamental rules that determine whether consent was rendered voluntary. Importantly, these rules, like the analysis of Erdman himself, overlook the fact that the voluntariness of consent must be analyzed based on the totality of circumstances.
That's what Sandoval says, my
Now,
friend.
hold on, let him finish. Let him finish.
And no statement, whether it refers to the consequences of refusing a blood test, the consequences of passing or failing a blood test, or otherwise should be analyzed in isolation because its impact can only be understood when surrounding circumstances are accounted for. In other words, allowing any statement by itself to control the voluntariness analysis contradicts the basic rule that voluntariness must be determined based on case-specific consideration.
Sure, of course.
And then they explicitly say, therefore, because of its flawed reasoning and the flawed case law that results from it, we overrule Erdman, which is what that Serrano case relies upon, is Erdman.
So Judge, so Erdman, just, by the way, didn't overrule Erdman in its entirety. So what they're saying is the construct. So let's think about what Erdman was. In Erdman, the officer read a statutory warning, okay, that said that if the person didn't give a breath test, that they were going to get blood. That's not coercive. That was reading the statute. So if you read the case that I cited, Serrano, and then there's Navarro after that. Good law.
So, and I want to give you time to look at everything, right? But I mean, this is just like right on point with this.
100%.
Right on point, right? So if Erdman is right on point with this, then okay. But if it's not right on point with this, then it's.
And Judge, then there's Sandoval as well. One of your sister courts just 2 days ago also ruled in an exact situation like this, where an officer gave the improper admonishments that, hey, if you give a breath test, I'm going to take you home. And
Okay,
that's what
so
was said.
I think that we're getting way ahead of each other. So let's, first off, we're not on the record, are we? Yeah, we need to get there. So, yeah, we're getting way ahead of ourselves. So, all right, Ramona, you ready? Guys, we're going on the record. If you want to talk, go outside, please.
Are you gonna move this out? Consider waiving her signature on that.
Yeah. Yeah, as long you can confirm. Okay, I trust you. All right. We are on the record in cause number 2505428. State of Texas versus Stephen Garcia. Today is February 11th, 2025. It's approximately 9:49 in the morning, AM. Guys, I'd like you to please announce yourselves for purposes of the record. State first.
Diana Davila for the state of Texas.
Mackenzie Watson for the state of Texas.
Jim Butler for Stephen Garcia.
Okay. So I think that we were getting ahead of ourselves here. We started without even going on the record. So today is day for trial. Both parties have announced ready?
Yes,
This should.
Okay.
we're ready.
So what we have here is just kind of a brief introduction and where defense has challenged the breath test in this case and its admissibility thereof. You guys have reviewed everything outside, correct?
Yeah, Judge, so just for the record, the state and the defense sat down in the back room and we kind of went through some of the motions. We went through the motion that I just filed. And then we also began going through the motions in limine. So, and then of course, we brought this motion to keep the breath test out. Basically because the officer gave language that was outside the statutory language that they are supposed to give when they're offering somebody a breath test. And we're alleging that he basically tells my client, hey, look, if you blow, and if you blow under the legal limit, I'm going to put you in the car and take you home. And the evidence will show that my client relied upon that. In fact, at one point, when the officer is cuffing him and stuffing him, he's like, well, wait a minute, you said I was going to get to give a breath test, because he believed that he was under the limit, wasn't going to register, over 0.08, and was relying on the fact that if he gave that test, all of this ended and the officer would cut him loose and take him home. And then, of course, after that, and after the officer said, no, we got to go downtown because our machine's downtown, he again repeated that and said, look, if you blow under, we're going to get in the car and I'm going to take you home. And again, repeated that. And my client relied upon that and thought that that would happen. Of course, that's not what's going to happen. And Judge, and based on your experience, it's also possible that he could go down there and blow under the legal limit and the DA could still accept charges for DWI. So that was impermissible language that should not have been given in this case.
Response?
And one other thing,
And if
Judge.
you're not ready yet, it's okay, because I know that we're
Okay,
kind
I was
of,
just giving her the opportunity of what she wants to do. We did review the facts on the motion. We agree that the facts stated were as reflected on defense's motion. However, we do disagree with the case law given to support the fact that just because of the statements given by the officer, the breath test should be excluded. The underlying case law has negative treatment by the Texas Criminal Court of Appeals, and there is other cases within the same jurisdiction that have different treatment. However, we have come to the agreement that because what the case given by defense, once it goes upon appeal, it is only reviewed for abuse of discretion. And the case that overruled or gave negative treatment to Erdman says the same thing. Basically, it is the totality of the circumstances, and if you're able to relate a certain link between what was specifically said to the officer and what the defendant believed to be true, and if that gave him a specific idea of what was going to happen or moved him towards the direction of the breath test versus the blood test. So I think we're both in agreement that the only way to resolve it is by you reviewing what was exactly said by the officer on the timestamp was given and using the court's discretion to come to the conclusion.
Let me ask you this. Have you had a chance to see whether Serrano, the case that he provided, I mean, it's right on point. Have you
It has not been
seen?
overruled, just so you know. And I think just to give you a little more information. So I agreed with that treatment of Erdman. I thought that it was not that great of a case. Because in Erdman, look, you had a officer that was doing nothing more than reading the statutory language. I mean, he wasn't even saying like, hey, go down there and give a sample. And if you are under, I'm going to take you home, which is like dangling candy in front of a baby, And that's the kind of thing that the law wants to prevent. The law says, here's the statute that you read. Navarro, which is another case that's cited among the cases that we're talking about.
I understand. Is there something that negates Serrano? Is there a case that says, hey, saying something like this is okay?
It would just be Finan, which is the Texas Criminal Appeals case that just states that it was not a breach of discretion to keep it out and that it would have to be a totality of the circumstances.
Okay.
And we 100% agree with that, and we know that. And so, Judge, what the other thing that I wanted to say without going into Erdman is the Navarro case talks about, it's very good, and it talks about what the statutory language should be and why it is there and what it informs the person. If you give a test and if it's over the limit, here are the consequences of that. If you refuse the test, here are the consequences with your driver's license. And then, if you refuse, we can get a warrant to get your blood. That's all they're supposed to give them. And then they sit back and then the person either agrees or they don't agree. You can't sit there and then start enticing the person by telling them things to get them to change their mind. And clearly you're going to see that on the video. This officer says these extrajudicial statements. Hey, if we go down there, if you blow over or under, pardon me, we're going to get in the car and I'm going to take you home. Now, if you blow over, you're going to be arrested. But if you ask for a blood test, then you're also going to go to jail. And, it could be a week or however long before that blood comes back. So he's thinking, man, I better go down there and give a breath because I'm going to go home. And you just can't be saying stuff like that.
We have a panel here ready to go. So I don't want to keep them waiting. They've already been waiting for, 30 minutes. So how do you guys want to proceed?
Judge, if it's okay with you,
Are you ready to argue the merits of this? Because what I was going to suggest is that we go ahead, pick the jury, and then we can just start and finish argument with this.
Well,
right after
the only thing that
I don't want to keep them waiting.
No, I understand that. The only thing is that kind of does change the voir dire a bit, doesn't it?
if you want to exclude the breath test part of your voir dire, then I guess it can be talked about. It's not totally excluded, even if it gets excluded, because we can't force them into specific facts that there is no breath test.
Of course.
So I think
I guess we're ready to roll. But and then we can.
I just want to keep the waiting. Let's get it started, and then right after we get done with the paneling, then we can.
Sure.
And then that'll give you more time to look to see if there's something else that you want to look at as far as case law or whatnot.
And Judge, we'll print a copy for the court of the 2 outstanding case law that we have.
Yeah, for sure. Okay. Any lawyers want to approach real quick before we bring the jury in?
Yeah.
Are you want to do your plea?
Yes, Judge.
Okay. Yeah, let's do it. All right, guys, if you're in the middle, we're going to ask you to please move over to the side because we're going to have a panel coming in and they're going to sit in the middle, please. So if you don't mind, please move it to the side.
I'm going to sign.
Yes, he's coming.
Huh?
I was hoping you could finish the brief.
Yes, no, we'll get it done today.
That's bad.
Hi, talk to me. Yes.
Approaching on Victor Navarro. This is an assault with a family member. His mom is here, who is the complaining witness as well. There's a protective order. I am requesting that the court lift the protective order. She is the only person to take care of him. I spoke with her this morning.
Spoke about a couple days ago.
No, this is new. This one is new for me.
It's on docket.
It is on docket today.
Is he in jail?
He is in custody. So I'm asking for two things today. One, a PR bond. He does not have any other violent criminal history. Also, no other cases pending. I'm not sure.
Let's read this. Shh, everybody keep it down, please. Hey,
Yes, Mom.
Alex, I'm going to read this. You ready? This is on Navarro. Okay, let me read this to you. This is why the magistrate did not give him a one, because I don't know.
Right, okay.
No adult criminal history, Harris County. No charges since 1999. This case, defendant is complaining witness's son. Complaining witness reports defendant got angry when he was asked to help move a shelf. Then later in the day, pushed complaining witness down to the floor and began punching her repeatedly, causing pain and scratches to her face. Defendant has been diagnosed with mental health issues. Complaining witness wants to press charges because he needs to learn his lesson and could possibly kill her one day if she does not take action. Her AFC defendant is not employed. Spanish speaker on AFC, English in court. Defendant declined PDO and appointment of counsel, but per PDO, he is 1622 consented to prior to docket allowed PDO to represent a PC. I need to talk to him. So, yeah. Yeah, let's bring him out.
Okay.
And we'll talk. All right, come on. Bless, you ready?
Yes, Your Honor.
Okay, come on.
Yes.
You are Alberto Lopez.
Yes.
Mr. Lopez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. Is it being reduced to a first? It looks like it's being reduced to a first. What you must understand that this is still two. So if you ever pick up another DWI, you will be facing a felony charge of a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, I would never get into a car and drive if you have even had a sip of alcohol because you were playing, you're taking a humongous risk. Do you understand?
Yes.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there is no changing this. It will go on your record. It'll be there forever. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty and we'll send it you to the agreement. I'm going to suspend your ability to drive for 1 year. Do not drive until you get a license. And good luck to you, sir.
Hey, Judge, and Your Honor, I was appointed to this case. I don't believe my client's financial status has changed since he's been in custody. Could we ask the court to waive the DPS fee? Thank you, Judge.
I'm gonna. Good morning, Mr. Navarro. Do you speak English, sir? If you're going to play games, it's just not going to go well, man. You know, really.
Respectful, please.
Your lawyer's asking me to give you a PR bond, but if I know now that you're going to give me issues, I'm just not going to do it, you know? my soul, the only thing I want to do is protect the public. Do you understand? So your lawyer is asking me to, give you a PR bond, but what I need to know is if we let you out, is there going to be a problem with mom?
Judge, I'm also going to do jail release instructions. So if we could do a jail release order so that he can go to the Harris Center. Mom is right here. Miss Francisco? The main concern, Judge, he needs to get on his medication. So I spoke with mom. If we can do a PR bond, I can do a jail release order for him to go to the Harris Center.
Blas is still here. Do you speak English, ma'am?
Yes.
Oh, wonderful. Okay. Are you okay if he goes back to your house?
I want, if you just wanted to get him like the getaway, that's what I want.
So what,
I wish I could just find a place where they could spend at least a month to make sure he is on the medications and stuff like that.
well, I can make it a condition of his bond that he's supposed to take his medication. And if he doesn't, then,
That's what makes him start acting out because I can't force it anything.
well, I am now making it a condition of your bond that, Mr. Navarro, if you want to be out on a PR bond, you have to take your medication. If you don't, then no more PR bond. Do you understand? I'm not asking for much.
He's not he doesn't know how to talk to people and, his mind is like sometimes not there, you know what I mean? He understands certain things, but I just have a problem with him. He takes it out on me, not no one else, you know what I'm saying? But I don't want to get him spraying on him because he's in there on the street homeless, and I can't let my son live in the street.
I got it. I understand. And I'm okay with it. Mr. Navarro, do you want me to let you out?
Let me out my home house, area.
You have to understand, though, I want you to take the medication. Do you understand? If you do not, mom is going to call us, let us know, and then you're going to be right back here with us. So I want you to understand the only thing I'm asking you to do is take your medicine and be nice to mom. It's not hard. When you take the medication, good things happen. Can you do that for me?
Yeah.
You promise? I'm serious.
Okay.
So mom, I'm going to give you, we're going to give her your phone number. So if you have any problems, call her, let her know. She'll talk to me and we'll take care of business for you.
Tell him that if the cops show up, he's not gonna get out, he's gonna stay here.
Come on, everybody.
Now, you say that, Junior, because we're here in front of the judge.
Okay.
But you have to take life serious, Junior.
Mm-hmm.
That hurts me to see you like this.
We don't want to keep you.
Okay, that sounds good to me, but still, okay.
Next time you're getting out,
Okay, I know.
you better.
Okay, Mr. Navarro, make me proud, huh? Just keep taking the medication. Good things happen, all right? Okay,
Thank you,
yeah,
Judge.
I'll grant it for you.
Thank you.
Okay, ma'am, any problems, just let us know. We're here to help you out, okay? Really.
So then they can't keep him in the hospital like for a
What we'll do is
month.
we can do jail release where we'll take him to the, no.
I will go to my holistics department and we will find resources for that. But I did explain to her that the Harris Center would just take him from jail, do the evaluation. They can't keep him there.
Problem is that at the Harris Center, we can't hold him. We can't force him to stay. If he wants to leave, he can leave. We just can't.
I know.
That's why we will be in contact.
But they have resources at the defender's office to help you out. So whatever you guys need. And then just stay in touch with us if you,
I'm trying to get out of the journey, but I don't.
We will
like
help
more.
you. We can help you do that.
we'll help. Okay.
Thank you,
very
Judge.
much. Thank you.
Judge, and that was for Navarro. Any bond conditions for?
No weapons and take medication.
Yes, Judge.
The state wants to approach on an extradition case. I oppose.
Your Honor, we're asking to approach on Nelson Morrow, call number 255-0421.
255.
0421.
Okay.
Your Honor, he is wanted out of Multnomah County, Oregon on 5 counts of sexual abuse. He's got a $1,250,000 bond. The demanding jurisdiction has requested a 3-day reset due to staffing issues.
Have you had a reset before?
I'm sorry?
Have you had one before?
A reset?
They
No,
haven't,
Your
Judge.
Honor.
They haven't. I have no object.
Okay, I'll grant it for you, but that's it.
Thank you, Judge.
Okay. All right. Thanks, sir. Okay, are you ready? All right, bring it on. Rock and roll. Guys, if you want to sit in the, Ramona, you're going to stay there? You don't want to go to where you normally go? Okay. All rise for the jury.
All right, for the jury.
Judge, read Michelle. Shuffling. Shuffling. Okay. Please be seated. Everybody, please be seated. So, ladies and gentlemen of the jury, something has happened. So I'm going to have you all stand up, go right back outside real quick. We're going to switch numbers and then I'll have you come right back in, okay? So if you don't mind, just please step outside momentarily. We're going to give you all new numbers and then we'll have you come right back in, okay? Please.
Judge, may we approach? It would be up to you, and I think we might have to go on the record for this.
Okay, guys, we're going on the record. Please do not talk. Ramona, you ready?
Yes.
Wait for that. Is that? Okay.
It has come to the state's attention after reviewing the criminal history for the panel
Okay.
prior to being shuffled. So previous juror number 1 is a convicted felon out of Louisiana.
Okay.
And I just wanted to approach the court to see if they wanted to disqualify them prior to going through the whole voir dire or after as an
Yes.
agreement.
While they're getting their new numbers, that might be appropriate.
Say it again.
While they're getting their new numbers and they're
Yeah.
doing the jury shuffle in the hallway, that might be appropriate. It'll be cleaner.
He's now juror number 4.
It's just cleaner. No,
Yeah,
we
okay.
agree.
Happy. All right, give me 1 second. Let me.
Sure.
Thank you, Judge.
Well, so I just want to get this on the record. So juror number 4 is because he
I need to
is,
hear you.
juror number 4, because he's a convicted felon, due to the agreement of both of you guys, we're not going to put him on the panel. And we're,
Sorry. You're trying to navigate it. It's,
because juror number 4 is a convicted felon, due to the agreement of both parties, we are not going to include this person into the panel. So we'll just keep that person off. We're going to excuse him. Are you okay with this?
I'm okay.
Are you okay with this? Okay, all right. So we'll just go forward without that juror. Okay. Okay. So once you're ready, you can bring everybody in and start. Okay, just don't include that person. Okay.
All right, for the jury.
Just, hey, Frank. Yeah, like we do with everybody. All accounted for? All right, everybody, please be seated. Good morning, everybody, on this wet and rainy day. Good morning. Oh, thank you so very much for coming. You should really pat yourselves on the back. Really, I know that the weather's kind of crummy. I know that it's hot, humid, that most people don't want to be here. Look, I'd rather be at home too, you know, but I really, your sense of civic duty, just, it's amazing. And I really, really thank you. And I love that we have such a great cross section of the community here today. That's what makes, you know, criminal justice possible. You know, a lot of other countries, a lot of other places don't have this. And that's what makes our system so great because, you know, without you guys, we just can't function. My name is David Fleischer. I'm the judge here in County Criminal Court at Law Number 5. It is one of 16 misdemeanor courts here in Harris County. So just to give you a brief rundown, I don't know what you know, so I'm going to go from the top. So what are we? We are one of the misdemeanor courts. Well, what's a misdemeanor? Okay, well, in Texas, there are two types of offenses. There are felonies, and then there are misdemeanors. Does anybody know what the difference is? Anyone? Anyone? Yes, so to speak. It's based on the amount of time. So a year and above, you're looking at a felony in jail. And below that, a year and under, you're looking at a misdemeanor. Now, within those two categories, there's always subcategories just because of there's so many different types of crimes, they have to subcategorize it. I'm not going to get into the felony because we don't deal with that here. I like to sleep at night and those just, yeah. Anyways, so now within misdemeanors, there's three types. There's A, B, and C. Class C misdemeanor types are the type where, let's say you get pulled over for speeding, you get pulled over for no insurance, or, you know, believe it or not, there's a Class C assault, disorderly conduct, whatever it may be. Depending on where you are in our city, because it's so big, you know, you may go to municipal court, which a lot of people know about here on Lubbock. If you're out in Katy, you may go to a justice of the peace court. If you're out in Webster, or if you're out in that area, Clear Lake, you may go to one of the justice of the peace out there. So depending on where the occurrence happened is where you might go. Here in our criminal courts, our 16 county criminal courts, we deal with only B and A misdemeanors. B are punishable, anything punishable by up to 180 days and or a $2,000 fine. And Class A misdemeanors are those that are punishable by up to a year in jail and or a $4,000 fine. So we only have those two types that we deal with here in our county criminal court at law. Like I said, we have 16 of us because of the amount of people that we have here. And I will tell you now, percentage-wise, I would say 7, maybe 8% of the people that are called upon to come for jury service actually show. It is such an abysmal rate that's why I really congratulate you on coming, because just we really sorely need more people to show up. Because like I said, without you guys, we just can't function. So what we have here, we have two sets of lawyers that I'd like to introduce you to. We have the state's lawyers, and then we have defense. State, would you please identify yourselves?
Yeah, no, that I'm from the state justice.
Does anybody recognize them? Okay, defense.
Good morning, I'm Jim Butler. Pleased to meet you all.
Does anybody recognize Mr. Butler? Okay, guys, please. So what we have now is we're here for a trial. I don't think that anybody disagrees with the law in general. What they disagree with is perhaps how things happened, whether someone is innocent, guilty, and that's why we have you here. we are really not asking you to split the atom. We're not asking you to do Pythagorean's theorem. All we are asking you to do is use common sense. What's going to happen is a fact pattern is going to be given to you guys. All we want you to do is listen and make a judgment call. I have told this time and again to all the jurors that come here, you know, you really know when you listen to someone in your heart, in your gut, whether that person knows what they're talking about or whether they're from outer space. That's all we are asking you to do. Any kind of preconceived notions, any kind of past things, you know, we're going to ask you, or they're going to ask you whether you have something that has happened in your life that would render you unable to be able to sit for this type of case. Okay, we're here on a DWI. And so they're going to ask you whether there's something that has happened. But at the end of the day, all we want you to do is listen and make a judgment call. Because you are the people that will listen, look at the evidence, and make a decision at the end of the day. So what we're going to do today is we will start with voir dire today, what we're doing, and then we will start with testimony tomorrow, and I anticipate that we will also conclude tomorrow. Is there anyone here that can't be here tomorrow? Anyone? Anyone? Okay, you are 1, 2, 6. Okay. Is there anyone else that can't be here tomorrow for any reason? You know, the last thing we want is we want you to get impaneled, and then for some reason you can't be here tomorrow. It's the worst. So that's why it's okay. We just want to know, is there something why you've got plane tickets, a doctor's appointment, one reason or the other that you can't be here tomorrow? Okay, so. Now, it's not just because you want to like have lunch with someone. It's like, you know, you got a serious doctor's appointment or, you know, plane tickets, not just because you've got lunch with, you know. So I got 5, 6, and 32. Is that it? Okay. Is there anyone here that is not comfortable with English? Doesn't speak English, speaks something different? Okay. And what number are you, ma'am? Okay. Anyone else? Anyone else? Okay. So what I'm going to do now is I'm going to turn it over to the lawyers. I'm going to give them each, you know, about 25 minutes to speak to you, get to know you. I know it's a short amount of time to get to know someone, but the idea is that the only thing that we're looking for are people who really have an open mind and are fair. All literally just listen and then make a judgment call at the end. That's all we would like. Okay, are you ready? Okay, floor is yours. Going? Can you move that?
Can we refresh it real quick?
I don't know that it needs to be, Judge, on the time limitation. I would ask to extend my time because this is a DWI, which I think is super serious.
I know 30 minutes is enough though.
I ask you, Judge, somebody stop them into like some account of like how those outcomes and what they want. I go to drive. So, you know, when they can start getting emotional or something like that, I would just ask if that happens, that you extend the time.
No, I mean, 30 minutes is sufficient. Okay, 30 minutes is sufficient. Okay, I mean, I don't want to go any more than that because anymore, it's.
Well, I'm not talking about a question. It's just something like that.
Let's go and let's see how it goes. Okay, all right. You get 30 minutes each.
Hello, everyone. Mackenzie. I represent the people of the state of Texas and this DWI trial against the defendants, Juan Garcia. Mayor. And so first I want to talk to you about, I have a little PowerPoint presentation here. And The
trick is you gotta unplug it, plug it back. Okay, hold on, let's see if it'll work here.
There you go.
So first I want to go over all the elements that I am required to do beyond a reasonable doubt of order to do this. So the first
This is a moment where Judge Fleischer delivers one of the strongest warnings of the hearing. Addressing Mr. Martinez, the judge explains the dangers of repeated DWI behavior and makes it clear that continued violation could lead to much more severe consequences. Legally, the court is not only addressing the current offense but also considering the defendant's history and the potential risk created by future actions. The judge emphasizes that driving after drinking can have life-changing consequences for both the defendant and others on the road. Do you think strong warnings from judges can actually prevent repeat offenses, or do some defendants only change after facing harsher penalties? The courtroom message is clear. Responsibility has to begin before another mistake happens.
Balance, inability to maintain attention.
Yes. Yeah. Anybody else? Come on, I know you guys know some sense.
Irrational behavior.
Yes. And if I can ask you all, when you do speak up, will you please flash your juror card just so we know which juror is speaking, and speak nice and loudly? Our lovely court reporter Mona reminded me earlier so that she knows everything we're all saying today. Okay, so yes, that. What else? Yes, juror number 10. Impaired judgment. Impaired judgment, that's a really good one.
Also motor skills.
Juror number 30, lots of motor skills. Cognitive.
What she said in here.
Cognitive impairment. And so cognitive impairment is a really broad sign of intoxication. What are some specific versions of cognitive impairment that we can see? Juror number 7.
Speaking vulgar or the opposite. They're very, my buddy, here, help me out.
Yeah.
They can go from one side to the other.
Yeah, like aggressiveness or being like overly familiar with somebody. I know a lot of people start giggling a lot when they're intoxicated, kind of think that something's funny, but it's not necessarily that funny. Anything else? Yes. Oh, yeah, juror number 24.
Can't necessarily walk or act straight.
Right? You can't walk or act straight, and that's a sign of physical impairment. I know we already touched on some of those, but are there any signs of specific physical impairment that we haven't touched on yet? Yeah, I know we talked about failure to maintain balance, kind of swaying while standing. Have y'all ever seen that before, where somebody's standing up and kind of are swaying from side to side, they can't stand up straight? Another one that I see a lot when I go out to the karaoke bar is I'll see people that are really overconfident. Like they just kind of keep the microphone bouncing a little bit. You're a little bit too intoxicated for that. So yeah, we went over these. Y'all are really good. You did my job for me. And do we see all those signs of intoxication on every person?
No.
No. And why not?
It depends on.
Yes.
Yeah.
Yeah.
You can have a high tolerance depending on your weight, how much what you're drinking, how much the alcohol content is.
Yeah, exactly. Like, wait, what was that?
Whether you've eaten or not.
Yes, that's a really good one too. So I have a friend, her name is Kat. She's pretty small in stature. She'll have a few drinks, but you'll see like so many different types of intoxication with her. Her face is flushed, her eyes get droopy, starts falling all over the place, but her blood alcohol concentration is probably around a 0.05. But even though she's below the legal limit of the 0.08, would you all still want to drive with her even though she was exhibiting those signs of intoxication? Would anybody here still feel comfortable driving with her, even though she was below the legal limit? Only, you would still feel?
No, she would be
Oh,
passenger.
yeah, good point, as the driver. So, I also have another friend, his name is David, he's what my mom calls his in drinking shape. So he can put down a 12-pack of beer, and then you can barely even see any signs of intoxication. Like maybe he'll slur a few words here and there. But would you all still feel comfortable driving with him if you knew that his blood alcohol concentration was above a 0.15? Even though he looked fine and he sounded fine. Would anybody feel comfortable with that? So kind of what I touched on is there are 3 different ways legally that I can prove intoxication in the state of Texas. The first is the defendant lacks the normal use of mental faculties due to the introduction of alcohol and or drugs into the body. The second is that they lack the normal use of physical faculties due to introduction of alcohol and or drugs into the body, or they have a blood alcohol content of 0.08 or higher. Now, the big factor here is that it's or. I don't have to prove all of these, I just have to prove one of them. So who here would require me, even if I proved beyond a reasonable doubt all of the elements of the DWI, if I was able to prove all the elements based off of the normal use of mental faculties or they lacked the normal use of physical faculties, who would still require me to bring a blood alcohol concentration of 0.08 or higher? Juror number 1? Yes. Okay. So why would you require me to prove the blood alcohol?
I own a bourbon company, and I've given out samples to people at various restaurants and bars. And I know that for me, it's very difficult to judge when either an elderly person comes in and they stagger because they may or may not have a cane, or they're on prescription medicines, or perhaps people who are overweight sometimes also have trouble with standing straight up. But I don't believe they're intoxicated. I'm giving them a free sample.
Understood. But even if I proved to you that they were intoxicated because they lacked the normal use of mental faculties through introduction of alcohol or drugs into the body, you would still require me to bring the blood alcohol concentration.
I would have to ask.
Okay, so if I were being married.
Would you prove that they?
Yeah, so if I proved to you beyond a reasonable doubt that they were drinking through the introduction of alcohol and they lost their normal use of mental faculties.
I would consider.
You would, okay. So can I get a yes or a no?
Repeat the question.
So if I prove to you beyond a reasonable doubt that the defendant lost the normal use of his mental faculties through the introduction of alcohol, and you knew it was through the introduction. Okay. All right. Who else is for yes, you're number 5.
The reason why I would require it is because similar to what he was saying, there's other things that can impair a person, such as medication. They might have a mental disability. They might have some type of physical disability, might have a combination of both. And so I don't.
But remember, all we're doing is we're asking you to keep an open mind. You know, all these things that you see now, it's all new, right? 30 years ago, you didn't have all this stuff. You didn't have blood test and breath test and this and no. Common sense. You know when you see someone, you know, how they are. So all right, just keep an open mind. You in your gut will know when you see that.
But it's okay if you would still need the VAC. I'm just asking whether you can follow the law so that we can have a fair trial tomorrow. So with that in mind, who here would require the 0.08 blood alcohol concentration to be shown at trial?
That's a good question.
Yes.
Does require, I'm assuming required means an absolute requirement. So for example, I think it would be a factor, even if there's sufficient withdrawal. But even if there's some proof of lack of use of normal use, I still think the blood alcohol level is a factor, but admittedly, it's not a requirement.
Understood. Okay. Yeah, and I'm saying, and that was if I proved the other 2 ways to prove it, or just one of those 2 ways, beyond a reasonable doubt in your mind already. So that makes sense. Yeah, sure.
Clarification. If one were stopped
along a highway, or perhaps whatever you stopped. Could the law enforcement officer arrest somebody for option 1 or 2, or would it only be based on the number 3?
So that's a good question. We are at the trial phase of this, so we're determining guilt. So there are different levels of proof that are needed, and I'll go over the beyond a reasonable doubt standard that we're here to prove. In order to make an arrest, you need probable cause, which means more likely than not. So it's a different standard that we're all here determining these elements for today. Yes.
So if intoxication is due to alcohol or drugs, and that person was under the influence of drugs and no alcohol, wouldn't they not have blood alcohol content?
Yes.
Okay. So that would be a case where blood alcohol wouldn't be necessarily a factor.
Yes.
Okay.
And then now we can move on to the beyond reasonable doubt standard. So what it does not mean is it doesn't mean beyond all doubt. It doesn't mean beyond a shadow of a doubt. It does not mean 100% certain in your mind. Because if it was 100% certain, what would you mean? If you knew everything that had happened and you knew all the facts of the case, what would that make you? Who said a witness? Juror number 1. Yeah, it would make you a witness to the case. And none of us were here on April 13th, 2024. Or there on April 13th, 2024, excuse me. So I have a little demonstration that I like to use. So who can tell me what that is? Can you have any guesses?
Jigsaw puzzle.
Yes, but what is the jigsaw? What is the jigsaw puzzle showing? Anybody have any guesses?
Giraffe.
A giraffe? That's a good guess, juror number 9. It's 2 giraffes. Oh. So yeah, before not a lot of us were very sure what it was, and now we can see even though some of those pieces to the puzzle are missing, we can tell that those are clearly 2 giraffes as the jigsaw puzzle. So like I said before, we're not going to have all the pieces because none of us here were witnesses, but we can know beyond a reasonable doubt what happened. So 3 questions that you should ask yourself when you're determining whether something is proven beyond a reasonable doubt is do I have a doubt? Is it reasonable? And does it go to one of the elements that has to be proven? And so let's go into a little bit about why we prosecute driving while intoxicated. So why do you all think that we have these laws? Juror number 10?
Because it can pose a threat to public safety, especially if you're traveling on an interstate highway with lots of traffic going through.
And who else besides the public can it harm? Well,
The driver.
correct, yes, you knew where I was going. Yeah, it's also for the driver's safety as well. So who here has recently taught a teenager how to drive? Anyone? Oh, yes. Juror number 13.
Yes.
So what was that like?
I have 2 teenagers.
Mhm.
It's a struggle. There's no doubt.
Yeah, there's a lot going on for them, right? Yeah, there's so many different things that we have to focus on. We have to focus on the road, we have to focus on the stop signs, we have to focus on the brake, and gas, sometimes turning up the radio if a really good song comes on. But we take for granted all the different things we need to focus on while we're driving. So when we introduce alcohol into our system and we dull those senses and we dull our mental faculties and we dull our physical faculties, that can be really dangerous. For example, you're driving through a neighborhood, you see a ball come across the street, what do you think is coming after that?
Child.
A child. Is that a situation where you want somebody who's lacking their normal mental or physical faculties to be behind the wheel of a car? No. All right. Now, who here is a fan of true crime? No, I'm a fan of true crime here. Okay, Gerda, done. What kind of evidence would you expect to see in a criminal trial?
Would do anything, eyewitness testimonials.
Testimony?
Interviews with the person arrested. Maybe any paper, it depends on what it is really.
Okay. So you would expect your, when you're saying interviews with the person arrested, do you mean like on camera?
On camera or paper, kind of depends, but we don't know what the case is.
Okay. Yeah, so in a DWI trial specifically, what other types of evidence would you all expect to see? Juror number 7?
Photographs, drawings of if there was an accident, how far did the vehicle travel, were there skid marks, did he apply the brakes at all? Test results, either blood test or breathalyzer
Right.
was administered.
Yeah, those are great answers. What about body worn camera or dash camera? Have you guys ever seen those on?
Yeah.
I know not everybody probably has TikTok, but I always see them on TikTok.
Depending on where you're at, some cities have them, some cities don't.
Right.
So that would be.
But yeah, sure.
I wanted to say my son had a little accident and his luckily had a dash cam, which helped him a lot to prove what happened.
Yeah, I appreciate that input during the briefing. Now, we can't expect to see all the different types of evidence in a criminal trial. So who here would require me, even if I proved all the elements beyond a reasonable doubt without body worn camera, who would still require me to show the camera footage? Even if it was proven beyond a reasonable doubt. Your number 10?
The camera footage exists.
I can't go into any specific facts of the case. This is just hypothetical. But I'm saying who here would still require me to bring camera footage if I was able to prove through testimony or other evidence beyond a reasonable doubt that the crime was committed? Who would still require me to show the camera footage? Juror number 10? Okay.
I just think it's important to capture the first few moments if an accident had occurred, and then that way you get a glimpse at what you're kind of getting into.
Understood, and I appreciate your honesty. Who else feels like juror number 10? Juror number 24?
I realize you can't in fact, but if there was a camera footage, I would want to see it. I would think that's very both parties that could be done.
I'm sorry, I didn't mean to keep your voice up.
I said if there was camera footage in existence, I would want to see it. I think that's fair to both parties, that the jury gets to see the actual.
But if it's not there, are you going to hold it against them? Okay, that's what we want. Open mind.
Okay, and then another question that I have for you all is a sliding scale question. So it's on a scale from 1 to 4, 1 being strongly disagree and 4 being strongly agree. And I'm gonna go one by one for each of you to answer this question. Is how important is it that we prosecute driving while intoxicated in Harris County? So we'll start with juror number 1, a 4. Juror number 2, 4. 4. 4. Juror number 5, 4. Juror number 6, 4. Juror number 7.
4 is the highest.
4 is the highest. Juror number 8. Juror number 9. Juror number 10. Juror number 11. Juror number 12.
4.
Juror number 13.
4.
Juror number 14. 4. Juror number 15 says 4. Juror number 16. 4. Juror number 17. 4. Juror number 18 says 4. Juror number 19. 4. Juror number 20. Juror number 21. Juror number 22. Juror number 23.
4.
Juror number 24.
4.
Juror number 25. 4. Juror number 26. 4. Juror number 27. 4. Juror number 4. Juror number 29. 4. Juror number 30. Juror number 31.
4.
And juror number 32. Juror number 33. 4. Juror number 34.
4.
Juror number 35. All right, thank you all for your honesty. I know you all weren't all very frustrated at the same time. All right. And then the last day, I just want to wrap up. Are any of you unable to sit in judgment of another person for any personal, moral, ethical, or religious reasons that you have? Juror number 7.
I used to be a police officer, sir, I went to quite a few accidents
Okay,
involving alcohol.
so you think you would be biased against the
And
defendant?
definitely biased.
Understood. Does anybody else feel, not similarly, but does anybody else not be able to sit in judgment of the defendant for their, like, any religious reasons, ethical reasons? Okay. And then do any of your friends or your family have any personal experiences with intoxicated driving that would prevent you or your prevent you from fairly and objectively listening to the evidence in this case? Juror number 26?
Yes, my brother had multiple DWIs, then he passed away from alcoholism. So I feel very strongly against.
Okay, so you don't think that you could fairly understood. And I know this is a really sensitive topic, so I really appreciate your honesty, because this is really important because we're dealing with somebody's liberty here. Juror number 5.
My grandpa struggles with alcoholism as well as my uncle. He recently was arrested. Now he's in jail for a DWI.
Okay, so you don't think that you could be fair and impartial on those things?
I'm going to connect it to my uncle because I see that could be.
Understood. Thank you. Yes, juror number 2.
I had a middle brother passed away.
Okay, so you don't think you could be fair and impartial on this case?
To be honest,
You can.
not sure.
Oh, you're not sure?
Not sure.
Okay, but as I said, it's very, very important. You have somebody's liberty at stake here, and would you want an out there from somebody on your jury? So do you think you could be fair and impartial?
I believe I can.
Yes,
I believe I can.
you believe, okay. Okay, thank you, Juror. Anybody else? Juror number 31?
I have, my dad and several uncles passed away from liver cancer due to, heavy drinking. So I'm very against alcohol.
Okay, but do you think you could sit in a trial, listen to the fact and render a fair and impartial verdict? Yeah. You think you could, or do you thank you, juror number 3. Juror number 23?
Yeah, I keep going back to the definition of intoxication.
Yeah.
Probably we're saying. I'm not wanting to implicate myself, but perhaps somebody that's had one beer and certainly can handle it, and nobody would know it except the person who's been. Is that person intoxicated based on he has had an intoxicant? Well, it's not beer. Is that person intoxicated?
So that would be up to you all as the jury to decide whether they had either lost the normal use of their mental faculties, their physical faculties, or if they were above a 0.08 blood alcohol concentration from that one beer. I think it would have to be a really big beer to get above a 0.08, but you never know. Like,
Remember,
The 0.08.
everyone's different. You know, you may be 6'2", you know, I'm what, 4'9", right? You know, I may be 150 pounds, 98 pounds. Every single person is different. Every circumstance is different. There's just no cookie cutter. There's just no, so that's why we ask you to keep an open mind, listen, and then you make a judgment call. Anything, I mean, we've all had someone that we know that has had some alcohol related issue in the past, right? Some you may overcome, some just all that, leave it out there, come in here with an open mind, listen. You will be able to make a judgment call by what you hear on the stand. You know when someone is just huffing, so to speak, like, you know, they got a car their grandma drove to the Piggly Wiggly here and back, you know, when they're trying to sell a car, or whether they're true to what they're trying to say. You will know, your gut will tell you. That's all we're asking, you know?
And I think what you were saying before too is we keep going back to the 0.08 not mattering, is that? Okay, so I wasn't saying that the option is not available. I'm trying to ask questions to see if the law will be able to follow the law. So the law is that I only have to prove one of those ways to prove intoxication. So if you would still require the 0.08, that would be raising my burden as the lawyer for the state of Texas. Does anybody else have any questions for me? All right, well, thank you all. I'll hand it over to Mr. Miller.
All right. May we have a stretch break, Judge, so we can switch over the AV stuff?
Please, take your time.
Here, let me help you. Because you want to close up that. There we go. All right. We got it going.
All right, floor is yours.
All right. So my name is Jim Butler. I'm an attorney here in Houston, obviously. I am older. I am also a father of two 20-somethings. My son just turned 23, and my daughter is 22. She's a student at LSU. For the father that said that he was teaching his child to drive, you know, I live over kind of in the Heights area, and they closed Northwest Mall. That's where almost everybody I know in that area went and took their kids to learn to drive. I took two children there to learn to drive. One, I even taught how to ride a motorcycle there. All right, so this is a driving while intoxicated case, and I'm going to try to be brief. I'm definitely not going to be able to go through all my slides because I have just a little bit of time. But one of the questions I'm kind of good, if it's okay with you, I'm probably going to jump around a little bit. Is that okay? All right. So I think it's important for you to know why we are here today. So we're not here in defiance of the DWI law. I'm not here saying that we think that you should be able to get out there and get blasted and operate your car. That's not what we're saying. We're saying that the laws are good laws. We just are not guilty of violating that law. It's that plain and simple. The people who are selected on this jury are going to be the first normal, non-law enforcement people with no slant, kind of one way or the other, that's going to hear the evidence. And the whole purpose of what we're doing right now, Attire, is to make sure that whoever sits on this panel and hears the evidence can do so without having like a preconceived notion against someone, or maybe like you've had an experience where you were just like hoping that you would get selected on the DWI panel. Okay. Another quick thing that I want to recognize is I cannot think of any time that I ever selected a jury for a DWI case where somebody was not deeply affected. So I acknowledge those who please show of hands again. I wasn't 100% able to see from over there, but I do believe, sir, I acknowledge what happened with your brother. And what exactly happened?
He passed away from pregnancy.
I'm so very sorry. And I'm going to tell you right now, I've not memorized that jury list. Okay, I'm just letting everybody know. I'm trying to be honest with you. I've not memorized that list. I wrote your name over there. I'll go get it. But the one thing that I do remember that you said is, I think it wouldn't. So obviously, when I'm in charge of this man's life, and hopefully I don't make any mistakes, which I'm terrified of doing, very frankly, I have to get a commitment from you. I know that sometimes it's hard, like especially in the DWI case, we're talking about alcohol. And if you were back there in the back and you were on the fence and you weren't sure, which way to go, kind of tilting a little bit. Is it possible that that experience might tilt you in favor of the state's theory of the case only because of your prior experience with your brother?
I would like to say no. Never being in that position before.
Yes, sir.
I'm not sure how I would react.
There's, I'm sorry, please. The state used to give an example, and I think it was kind of funny. It was, you're about to go on a business trip, you're going to a conference in Las Vegas. Your wife says to you, now, hey, don't go to one of those, shows or anything, or don't, mess around. And you say, all right, I think I can do that. You have to be able to say absolutely, no, not going to happen, or yes, I need to have an answer.
I would say no.
No, it will not affect your decision. Okay, thank you for that answer. Is there anybody else here, again, looking into your heart of hearts, is there anyone else that thinks that, or has had anyone who's had an experience with alcohol? Either you or a loved one, juror number 26?
Like I said before, my brother had been arrested, I think over like a multiple year span, about 5 different times. He served prison time and he passed away about 8 months ago from alcoholism. And I try to be fair and, keep an open mind, but I really just have a zero tolerance with that kind of behavior.
Absolutely. I understand. And thank you for your definitive answer. You said there's absolutely nowhere way.
Not with that.
And is there anyone else that agrees with her answer? Juror number 7, you had mentioned your experience, so definitively you could not be fair. And I'm going to go row by row. I'm ADD as can be, so I got to go take it in small bites. Okay, and
I'm good.
you're good. Ma'am,
I grew up in alcohol with alcohol father. What number is that?
that's juror number 18.
So I'm extremely opposed. I can't understand what she's saying.
You don't have to holler.
I'm opposed to alcohol
She's opposed to alcohol.
because of growing up with an alcoholic father.
And do you definitively think that that experience would keep you from fair in this jury? And do you mind if I ask the judge to excuse you for cause for that reason? Is that okay? And anybody else? Okay, on the third row. Juror number 27.
I just don't agree with it.
I'm sorry?
I don't agree with the drinking and driving at all.
So the law in the state of Texas says that you can drink alcohol and operate a vehicle as long as you're not intoxicated. And you just cannot follow that law. Okay.
Isn't this your opportunity to see that what is done right? There's few times in life you're going to have an experience that you're going to remember forever. One of those is when you sit on a jury. Everybody hates coming here, but when they leave, they're like, wow, what a great experience. I learned so much by just sitting and listening what happened. It truly is a great experience. You don't see it now, but when you leave, it's a different story.
As I mentioned before, my uncles in jail right now from it, and my grandfather, both of them, and they have alcoholism due to military service. And so I think of it systemically, and so that's why I have like a more emotional pull.
And so you don't think that you could be fair because of the type of case that this is?
Yeah, because I know my uncles, I feel like there could have been other things that could have been done outside of a jail sentence.
And just to follow up, juror number 27, you don't think that this is the right trial for you? You don't think you could be fair?
No, I've been on juries before and
Yeah.
so I have no problem doing it. It's just this particular, I'm just thankful that my brother never killed anybody or so I don't understand the point, of people even thinking it's okay.
And that's 100% what I want to hear. There are no right answers. I'm not here for you to please me or give me an answer that I want to hear. I just want to hear what's on your heart, what's on your mind. Obviously, this is a DWI trial, so I just want to hear what you have to say. I'm gonna throw this one out. Who here right now has something in their mind and they're saying to themselves, man, if he only knew this about me, he would not want me on this panel. If he only knew this about me, if he knew this thought that I have about DWI, he probably wouldn't want me on this panel, on the first row. I know I've heard about your experience and I 100% acknowledge that. And I respect that and thank you for your saying. Anyone else? If he only knew this about me, he wouldn't want me on this panel. See, look, it's okay. You know, if I went out to my car and somebody broke into it and stole all my stuff, and then I was going to jury duty and somebody broke into a car, that's probably not the case that I need to be on. Do we all agree to that? All right. So let's go over that. Is there anyone here who's a member of MAD or who contributes to the Mothers Against Drunk Drivers? Anybody that contributes to that? And I know that you were in law enforcement. Anyone else in law enforcement or anyone who aspires to be in law enforcement? So credibility of witnesses. The law says that everybody starts off at the same place. Nobody gets to start ahead of the line a little bit. But look, let's face it, we all have beliefs and biases. Man, I'm from Waco, Texas. So, you know, and the best thing I did in my life was to come to Houston. But, you know, something, people there, I mean, you were taught law enforcement, you know, law enforcement can't ever be wrong. They can't make any mistakes. That's kind of how I grew up. I'm just telling you, that's how I did. And then I, you know, started doing criminal law, and then I realized that, you know what, an officer's, here number 6, you would agree, a police officer's just a regular individual, right?
They all start out as regular individuals,
Yeah,
but as time goes on,
it changes.
it changes perhaps your view, the way you view things.
Have you ever seen an officer make a mistake?
Many times.
So all I'm asking is, can everyone start a police officer off on the same line as you would any other witness? Or, and this is 100% okay, is there anybody here who would give an officer more credibility than I'm going to come to you? I'm going to take it line by line. If I don't, trust me, it's not going to be good. But could everybody give them the same credibility, or is there anybody that would put them a little bit ahead and give them more credibility? So the law says everybody's the same, but I need to know if you might give them just a little bit of a head start, like in my picture here, on the first row. No? And by the way, don't be afraid to say yes. I would be so afraid to talk if I was on a jury, really. I'd probably just don't call me. Anybody on the second row? Sir? Yes, sir.
Clarification, in the last 2 days, there was a situation where apparently 2 officers had fired a gun at a suspect. And once the video camera was analyzed, they had determined, I'm not making this, I'm trying to repeat what I read in the paper.
Sure.
Once the video was analyzed, the suggestion was that the suspect was turning away from the officer instead of toward them. So video evidence does change opinions. But I guess I would want to say, given a police officer's word versus the non-police officer's word and training and how to see it and everything, I would probably give some preference to police officers just for that reason.
So the thing you're describing is 2 officers said something happened, the video showed that it didn't happen, but you're saying that you probably would be more inclined to go ahead and believe them that it did happen the way they said.
Video evidence to the contrary.
Yeah, that's okay. That's perfectly fine.
Give the law enforcement person, based on their training and experience,
Sure.
more credibility than the other.
And what was your jury number? And so the law says you're supposed to give everyone the same credibility, like line them up the same. But you're saying that you would probably put the officer just, give them more credibility just off the bat.
I'm trying to respond to your rhetorical question.
No, it's okay if that's the case. That would be the case, right? I'm sorry, I'm not trying to like pull you into anything, but I think the answer is yes, that would probably be, I'm doing this for the record. She's got to type this down, so we just have to have a definitive yes.
I respect your law enforcement's training and experience in terms of being able to analyze and see things maybe in a different perspective than I would, maybe non-law enforcement training.
Okay. And if you were selected on this jury, you would weigh all the evidence and then you would make your own determinations. But you still probably would give them a little bit more because of their training and experience.
You just answered two separate questions.
I'm sorry. Okay. Is there anyone else that feels like juror number 23?
I don't think I'd give them more credibility to start off.
Sure.
But in the long run, I would value their testimony more.
Okay.
But I wouldn't say from the beginning, I wouldn't give them the advantage. I would just say that hearing their testimony.
And that's all we want. And that's why we want, like I said, those of you who are selected on this panel are going to be the first non-law enforcement people to look at the evidence. You're going to be the first like citizens. And this is the beauty of the jury trial, is if something happened to you, or heaven forbid you got charged with a crime. Yes, juror number?
No, she was asking me to show my number.
Oh, juror number 31. I have a couple helpers who are helping me because I can't see everything. Okay. All right. Anyone else have? Yes, sir.
I feel the same way. I just think that the police officers much dedicated to the well-being of the community. And as a member of a minority, I very much count on the police to ensure safety for me and members of my community. And so I just think there's no question in my mind that I would give more credibility to the police officer. I don't think it's impossible for the police officer to be wrong, but
okay.
I definitely should give them credibility.
All right, I appreciate your honesty on that. Thank you. And your number is number 24. Okay. Anyone else have a comment about that?
I have a question.
Yes, sir.
What about expert witnesses? Like, how does that differ from regular witnesses?
So,
not on this case, just in general.
In general, so you would judge their credibility based upon what they say? Yeah, you're going to take it all in. You're going to listen to everything. And that's what we want. We want inquisitive minds that are not just going to say, oh, okay, they're guilty because they say he is. And we threw some, whatever in there. We want people with curious, inquisitive minds that are going to sift through the evidence and then make a determination. Now, just quickly, because I'm burning up some time here, tell me on this scale, which best describes you? Number one, I've never consumed alcohol. 2, I used to drink, but I no longer do. Number 3, I'll have a drink, but only on special occasions, like weddings and things like that. And then number 4, I drink and I do so responsibly. Starting with number 3, and juror number 2, a 4, juror number 30, a 4, juror number 5, 2, juror number 6, 1, juror number 7, 2, juror number 8, 3, juror number 9 is 3, juror number 10 is 3, juror number 11 is 3. On the second row. 4. Juror number, please. Sorry. Juror number 12 is 4. Juror number 13, 9. Juror 4. Number 14.
8. I'm 3.
Juror number 15 is a 3. Juror number 16. 2. Juror number 17.
3.
Juror number 18. A 2. Juror number 19.
4.
4. Juror number 20. A 2. 21. 2. A 2. 1. Juror number 22 is a 1. Juror number 23. 4, juror number 25, 4. A 1, juror number 25, a 1, juror number 26,
2.
a 2, juror number 27, a 3, juror number 28, 2, juror number 29, 4, juror 30, 4, 31, 1, juror 32, 4, and 33 is a 4. So I've grown up, but most of us have our entire life seen this sign, right? Y'all remember seeing them blinking on the side of the road. Drink, drive, go to jail. But that is not the law. So the law actually in the state of Texas allows individuals to drink alcoholic beverages and drive as long as they're not intoxicated. Now, about myself, I love to go to Loopy Tortillas. It's kind of like our treat on the weekend. Sometimes before, when we go there, you know, you're waiting, the first thing that the waitress says when she comes up to the table is, what? Can I get you something to drink? And so I usually will have a margarita while we're waiting, and then we eat, and then during that, I may have a beer. Does beer stink?
Yes.
Is it not the most disgusting odor? I mean, really, like, I sometimes wonder, even when I drink a beer, like, when did we ever decide, like, that this is good? Like, it's so, so do you think that a person could be drinking a beer and driving home and then they get pulled over? What do you think they're gonna smell like?
Yeah.
Hello, officer?
Yeah.
Right? What do you think that officer is gonna think? Especially if it's early in the morning. Let's say they're coming home, they've been at their family's house or something, they've been hanging out, barbecuing. They're fine to drive, but they say, hello, officer. You think that that officer is gonna think that, you know something, I might need to check this person out. You think that could happen?
Yeah.
What if you have not been stretching? And I'm gonna tell you something about myself y'all don't know. I've had 2 complete hip replacements. Isn't that something? You wouldn't know it if I didn't tell you that, because I know I'm in such good shape. Y'all probably thought I was a gymnast. But I've had 2 complete hip replacements. How do you think that that would affect my ability if after coming home from Loopy's, I got asked to step out of the vehicle? First of all, if that happened, who thinks that they would be just swallowing their tongue? They'd be so nervous. Who thinks they'd be nervous? Anybody? You think you'd be nervous in that situation? I love it. My daughter, by the way, I'm going to brag a little bit. She used to be on the U.S. women's gymnastics team for 2 years. She got to represent the U.S. in Jesolo, Italy. And then, you know, COVID broke out, and pretty much that was kind of unfortunate for her career after that, because they weren't able to practice. But a gymnast practices their entire life on the beam, learning how to, you know, and how many people have seen somebody walk on a beam in gymnastics? What do they use when they're walking? They use their arms, right? Why do we have arms? For balance. Would it be fair to ask somebody to walk like a lion and tell them, hey, but you can't use your arms for balance? Like, if you wanted to design a test that made someone appear like they were off balance and kind of like clumsy, would you tell them, hey, walk like you normally walk? And by the way, walking that tightrope, you can use your arms? Or would you tell them, no, leave your arms down by your side? Which would you tell them? So we're going to ask you to look at the evidence, and you're going to make your own decisions. Like we talked about earlier, you're going to get to decide what is proof of impairment. All right? Everybody think they can do that? Yes, ma'am.
I'd like to add something, not about proving, but just about decision making.
Yes.
My uncle loves beer. He can drink, I don't know how many beers. If he knows he needs to drive, he will take 0.
Right.
0 beer.
So let me ask you.
It doesn't matter what the police going to do to stop him. and ask him, he will take 0 beers.
Done.
So
So-
that's a beginning of everything, making a decision.
I am not disagreeing with you. And I think that we all agree that anyone that drinks alcohol, what's the first thing that kicks off a DWI? What do you think it is? Anyone? Odor of alcohol. Right?
5 minutes, Mr. Butler.
DWI is an opinion crime. Right now, we're here today because of an officer's opinion. An officer had the opinion, like it's one of the few crimes where you can arrest somebody based on your opinion. It's not like, hey, well, here's proof that this person committed a crime, here's the video of them doing it. It's, hey, in my opinion, I think this person committed a crime. We are here right now, all of the evidence that the state has, the entire power of the state, everything that they have right now to this point gives them probable cause. Now, your job, those of you who are selected on this panel today, is to decide at the end of the day, have they ruled out every reasonable doubt? If a person can't walk, you're going to look at everything, you're going to hear the circumstances and the facts. It's got to overweight. There are other issues that he's got, and you're going to decide at the end of the day, is the only evidence of impairment just because of the introduction of alcohol. And if there's an innocent explanation, then you will find that person not guilty. Here's the important thing, the important distinction. Finding somebody not guilty doesn't mean that they didn't do something. It just means you didn't believe so beyond a reasonable doubt. And Judge, what's my time? I'm going to finish probably with this.
4 minutes.
Okay. So you've all heard of capital murder case, right? We've all heard people being given the death sentence. The burden in that case is proof beyond a reasonable doubt. So before you can stick a needle in somebody's arm and, kill them, the proof has to be proof beyond a reasonable doubt. Here's where we are right now. So in this little DWI trial, the level of proof that the state has to prove this case is by the same as you would a capital murder. Here's where we are right here. Probable cause. It's like a ticket. That's where we are. That probably something happened. Now, how many of you have children? How many have children? The state comes and they said, you know what, we heard about you. You're a bad father. We're taking your kids. You gonna fight them? Or how much evidence do I gotta bring? On a football field, do I gotta take the ball to the 99-yard line to take your children? Should I pack a lunch? You gonna fight me? To take your kids? Of course. How much evidence do they have to bring? Then you can bring it up. Okay. So that's called clear and convincing evidence. The evidence needed to take your child from you is clear and convincing evidence. In a custody battle, somebody says you're an unfit parent, we're taking your child. You'd have to bring your A game to take my children. I will fight tooth and nail for my children. That is proof by clear and convincing evidence. The burden of proof in this DWI, at the end of the day, is proof beyond and to the exclusion of all reasonable doubt. So I'm going to ask you something about that puzzle that they showed you. The giraffes, right? Pretty obvious. So tell me, could they prove that the giraffe limped? Could they prove that the giraffe was healthy? Because this DWI case is a little more intense than just identifying, a picture of him and saying, is he a human? Is that a giraffe? Because we're getting into the mind. We're getting into whether something affected that giraffe. And you're going to listen to the evidence in this case. And then at the end of the day, you're going to make that determination of whether or not this person was intoxicated. That means that he no longer had his mental faculties. He no longer had his physical faculties. And folks, that means you've lost them. You don't have them. It's not buzzed driving. it's you've lost them. You no longer have them. Can everyone hold the state to its burden of proof? Can you? Who wants to be on this jury? Show me your hands. On the first row. I'm gonna take it row by row. Who wants to be on my jury? Any takers? No. Nobody wants to be on this jury. Thank you. Juror number 10. How about you, juror number 11? You want to be on here? Yeah. Do you want to be on my jury? Okay, I got 10 and 11. How about you, juror number 9? You want to be on here?
I will, but.
And you're on here when you promise to listen to all. Yeah. Juror number 8. You good? All right. Now we're getting somewhere. And I know about your issue. Juror number, you can be with me. You can be on this panel. Juror number 3, is this maybe not a case you want to be on?
I'll do it. I prefer it.
You prefer not to? Okay. How about you guys? Can I count on you? Be on here? Gentlemen?
Yes.
Sir?
Yeah.
What's your thoughts? You haven't said a lot.
I don't know, I have a lot of thoughts.
Talk to me.
I don't know. I got for drinking and driving when I was in high school, right? And I don't think I've ever drank too much to drive. Never drove over the limit since then.
Yes, sir.
Almost never driving and drinking.
Yes, sir.
Also was in a court where I got through out because the police officer didn't prove it beyond a shadow of a doubt and came with some things that the judge dropped. So
Okay.
I can kind of see both sides of the coin.
Okay. All right. Thank you for your honesty.
Yeah, I
Where's that
don't
accent
really
from?
want to be here tomorrow, but I will be.
Okay. Where's that accent from?
Northwest Iowa.
Okay. I could hear a little bit of something. Sir, what do you think? You want to be on here?
Yes.
You good? All right. Good thing. You want to be good?
If I have to, I'm good.
No, you don't want to be on here. No. Okay, thank you. All right, well, I'm going to sit down.
You forgot the back row.
Well, okay, hold on. Full disclosure. Okay, let's all get it out and be honest here. So what happens is we all have 3 strikes. I have 3 strikes, they have 3 strikes. And that can be for any reason. You know, the person looked at me weird and I felt weird about it. And then we get to strike people for cause. That means like, sir, when you said you couldn't be fair. And so I was just doing the mathematics. And I was kind of saying, okay, we might not get to the back. But I didn't mean to leave you out. I honestly didn't.
We still love you back, bro.
I was horrible at math, so I might have messed this up. But is there anything that I left out? Please tell me. Is there anything that I didn't bring up? Is there anything that you want to say? Yes, sir.
Is this a first offense?
So we can't even go into any of that stuff. Yeah. Yeah, but I'll tell you what, after the trial's over, I'd love to go sit back with you guys. I'd love to talk. But I'm on a very short leash here, so, because I got some other good stuff I wanted to go into. Judge, what's my time?
No, it's over. I mean, I have to be,
How about one last?
no, you've gone over time. I have to be fair to both sides.
Okay,
That's it.
not even the constitutional presumption of innocence.
You had the same amount of time as the state. I have to be fair to both sides.
All right. Well, listen, folks, thank you so much for putting up with my war hour. And this is a very serious day for us, extremely serious. And thank you for those that said that they wanted to be on my panel. And we look forward to trying this case too. All right, thank you.
All right. Lori, if you want to come on up. Ray.
I don't know if you want an interpreter to yell at him.
Did he test positive or negative? No, I'm not. Come on up. Gomez, come up. I'm not going to yell at him. You know, he's testing positive. He's got bond violations. It's not going to happen. Take a seat for me in the jury box. I got to wait for an interpreter, you know. So I have to call an interpreter. Take a seat for me in the jury box. You're not allowed to go. I can't just, so I don't know. Let me wait for an interpreter to get here. I don't even know what happened, what he tested positive for, but I'll address it as soon as the interpreter gets here. Owen, come on up, sir.
Judge, I have two separate clients, but they're in the same transaction on your docket. These are the two illegal dumping cases that they were here on Friday or Thursday.
Okay.
Nicholas Rubio. The other one is Rodriguez Arturo.
Okay.
They came to my office, they signed the agreements to take the cleaning agreement. They brought me the $100 to pay the fee. I emailed Mr. Goldberg. Mr. Goldberg says he can speed up entry into the program. So what I need to do is tell him now what day they can do it, which will be a Saturday, and I'm guessing we can get it done pretty quick. Couple of weeks.
You have the day? Well, I want to make sure that you guys actually sign the contract and get a firm.
Yeah, we've already signed the contract. I've got the money to pay the fee, but I have to notify him of the day for them to work. So I'm guessing it'll be Saturday, and then he'll pick the first Saturday available.
I'm not going to set it a couple weeks. I mean, I want to know, like, let's set it a couple days out so I make sure that you get the day. So today's Tuesday, I'll set you to Monday. Come back on Monday and let me know what day you got so that we can stay on top of it because it's getting old.
We'll get it done.
Okay.
Did it get past,
Hi, Judge. Frank, you ready?
John?
Do you need a translator?
No, he speaks English.
Come on up, sir. This is
Lenin Arauz.
This is Arauz.
Arauz. It's a .09, Judge, but just let you know.
Shh. You are Mr. Arauz. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, I had to wait probable cause unless you want to hear it.
Anything egregious? She said
No, it's
109.
.09.
The vehicle had driven up to the sidewalk, but other than that, it is a .097.
Okay. So there is probable cause to go forward with your case, Mr. Arauz. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. No more PR bonds. Do you understand? Do you have does he have a valid Texas driver license?
Yes, Judge, and I'd like to bring something else to the attention of the court. It was 6:30 in the morning and he is 17.
Oof. No more. If you have a problem with drugs or alcohol, you better address it because if you don't, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand? No alcohol, no illegal drugs, and I'm going to test you. If you don't believe me, ask Frank. I don't want you using at all. I don't care where you're going, what you're doing. Do you understand? Okay. All right. I'm going to have you meet with Felicia for your bond conditions, and then we'll send you on your way. Because you have a lawyer, I will waive your appearance, so you don't have to waste your time coming to court, but you have to stay in touch with Frank, and he'll tell you when you have to come back to court. If he tells me that you start playing games, you pick up a new case, you don't remain in contact with him, I'm going to issue a warrant. You understand? Okay, man. Good luck.
Judge, have a good day.
Sorry, I would
Frank.
just like to request if possible, if we could put in his bond conditions to continue going to school.
Yeah, I'm down with that. Is he in high school?
Yes, Your Honor.
Okay, it's a condition of your bond that you remain in high school as well, all right? You either work full-time or you're in high school full-time. You know, when
He
you
is working full-time, Judge. He does work.
if you're in high school, right? When you have too much time on your hands, people become self-destructive. So you need to occupy your time, do something worthwhile. All right?
Yes, sir.
Okay, bud. Good luck.
Thanks, Judge.
Okay, who's next? All right. Come up. Deputy Miranda, I'm going to need your help. Gomez. So Felicia, what did Mr. Gomez test positive for?
Judge, the results came back presumptively for THC and cocaine.
Unacceptable. I am now, you have a bond violation for tampering with your device. I now send you for a drug test. You test positive for cocaine and THC? Nope. Goes with you.
Judge, if I may, may I make some argument, Judge? Okay. Judge, so he is a plumber. Part of his duties as a plumber is sometimes he has to work in water. Because he has a device, he has to wear long rubber boots. The day of the tamper was Tuesday, and it was during work hours. The time of the tamper, the alleged tamper was during work hours. He claims that he received notifications that the battery wasn't working, and he took it to Sentinel and Sentinel replaced it. We tried to verify that. We were not able to verify that with Sentinel. However, despite that, I believe that maybe those rubber boots that he had to wear that day because he was submerged in water at that point, probably had something to do with the device not reading appropriately. I mean, they're big, thick rubber boots that are waterproof. In addition to that, Judge, he is a father. He has a 1 year old, 1 year, 4 month old, and the mother of the child that are dependent on him. He is the primary provider for the family. I've admonished him that he is not to do anything, no drugs, no alcohol, no nothing, can't mess with his device. If anything ever comes up again with his device where he has to go in, he needs to notify me. So Judge, we'd just be asking for him not to be revoked at this time and give him another opportunity. If the court would like to.
He's not gonna do it, right? He's testing positive for cocaine. I've ordered him not to use at all. I'm sorry. No.
If the court would like to do random UAs instead, Your Honor.
Or just what we're doing now. It goes with you. Your bond is revoked. Sorry, Ray. I can't. I mean, I was prepared to do that with that, but you're testing positive for cocaine. Unacceptable. I can't just let you go with that.
Yes, sir.
No, because then I become the enabler and I'm telling you, hey, man, it's okay for you to use. And it's not. No. I love you, Ray, but.
He's just gonna get a nice hold and.
Well, I don't know that, but hey, this is a second DWI. You already have a bond violation and now you're using? I mean, I can't just continue. I get it. He has to understand that actions have consequences. This is not our first rodeo. It's a second DWI and he's using?
Yes,
sorry. Okay. 5,000. Tony. Ready.
Custody case.
Okay. Deputy Chigoin, do you mind helping me out? I need someone brought out in back.
No, that's not right. Check. I'm sorry. Who's the plan?
Montoya, okay. Come on up, Mr. Montoya. Thanks. Mr. Montoya, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 50 days in jail with credit for the 50 days that you've done.
Yes.
Oh, he has another DWI. Did you see that?
Well, there's a question whether it's in.
So Freestone County has a hold on this gentleman for a DWI above a .15.
He doesn't acknowledge that, Judge.
He has a prior DWI from the same place. You need to realize something, Mr. Montoya, that this now may very well be your second DWI conviction because you're pleading guilty to this DWI. Once you have 2 DWIs, when you pick up a third, you're looking at a 3rd-degree felony, 2 to 10 in the penitentiary. Is that what it's going to take? Prison time? Some people only learn the hard way. Is what it's going to take. Watch the news. Every single day in our county here, someone dies from a DWI when it is extremely easy. One button on a phone, an Uber will take you wherever you need to go for $30 freaking dollars. From now on, you may be very well facing up to 10 years in prison, even with a sip of alcohol because of your record. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. It will be there for the rest of your natural-born life. Do you understand?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
Don't kill anyone. That's all we're asking. Don't kill anyone. We have enough death on the streets as it is. You have a DWI here, you have another one open somewhere else. You have one from last year. What's it gonna take? I'm suspending your license. Is this pled as a first or is it pled as a second? I'm suspending your license for a year. Do not drive. Stop driving.
Pled as a first investigator.
I'm not asking for much, man. Really. Good luck to you, man.
Nice old judge.
He still has another DWI in another county, man. Really. This Williams, or what is your true name?
It's Williams Newton. Thank you. I brought my ID.
Yeah, I gave him his ID, her ID.
ID says Newton.
It's Williams.
So it says Chrysanthia
Williams Newton.
Williams Newton.
Newton.
Okay, so we'll do a name change to that, whatever that ID says.
Okay.
You are charged with 4 counts of, I'm sorry, with, is it 2 counts of theft?
3 counts of theft, 1
Counts
failure
of-
to ID.
1 failure to identify oneself, giving fictitious information. You need to understand, ma'am, is that when you have multiple thefts, at some point, they're going to hit you with a felony and you're looking at days instead of years. The agreement that you've worked out is they're going to dismiss 3 of the cases for your plea on 1. You have 1 prior theft, and it's very possible your next one may land you in felony court where you're looking at years instead of days. Do you understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record and you can never take it off. Do you understand? Like I said, 2 thefts plus when you get a new charge, a 3rd one, you're looking at a felony charge. Do you understand? They can use this to enhance your punishment. Not only that, from now on, you're looking at a minimum of 90 days in here for any new cases that you pick up. You understand? Do you still want to do this?
Yes.
How do you plead to the offense of theft, man? Guilty or not guilty? I will find you guilty, sentence you to 12 days in jail. I'll give you credit for the 4 days that you've done. Good luck to you, man. Please see the clerk. Okay, thank you, Mr. Bonds.
I got called in.
You guys know Mr. Butler's still here?
I saw him in the attorney room. Do you need him?
He's still there? You want to grab him real quick? We can talk about your motion. Do you have? You ready?
Yeah.
Okay, shh. We're going on the record. This is a very interesting issue. I've really never run across something like this before, where they really have just out at the outset said, hey, man, if you blow and you're under, we're letting you go home, which is essentially what's happening here, right?
Yes, Judge.
Do you have any case law that says that it's okay to say that?
We have case law that says that the case that he used is overturned.
Judge, and we also have Sandoval v. State, which is from May of 2000 from the Court of Appeals of Texas, and it does.
You're saying May of 2000. When was this case?
I think that one's pretty old.
Oh, this is 95. Okay.
And it's from
What case do you have?
Sandoval.
Can I see a copy?
Yeah, you can keep that.
Oh, I think I actually, Judge, may I? hand you-
No.
Okay.
They're talking.
Yeah. All right.
So Sandoval is almost the same thing as, or, I forgot the last name, but
It's the same thing.
I already know your position.
So-
I'm trying to get theirs.
it states the same thing. And the officer in this case with the facts stated, if you blow under, you can go home. And the Court of Appeals held that the court did not abuse their discretion by letting in the breath test, that it was statutorily, it was outside the statute outside the statute requirements of the DIC reading, but that it didn't
A court
directly
found that was not,
abuse of discretion from the trial court. Yes, Judge. For Sandoval.
okay, so but they let it in.
Yes, Judge.
Right. But is there something that says if it's let out, it's an abuse of discretion?
That, no, Judge. It's just case by case basis at this point.
Is it?
Yes. This is the newest one from 2012. That goes directly into the case law that defense uses, and this is Sandoval.
Okay. Okay. So, have you seen the cases that they cited? Okay.
I know these cases. May I point something out to you?
Sure.
Was that Navarro that you just read?
I think I'm looking at your Finian. I don't think it's on point. I mean, this is just whether this guy was more afraid about getting stuck by a needle, and that's why he wanted to blow as opposed
100%.
to, whereas this one's more on point where I think it go either way.
It's 100% on point. And then what I wanted to point out to you was, I believe that was Sandoval that you were just reading.
Yeah, Sandoval.
Okay, so in the in the Sandoval case, the court said the only case we have found, they'd found concerning this very specific issue, the validity of consent given the hearing consequences of passing fail on a breath test, is State v. Sandoval. So they recognize that Sandoval is still good case law. They keep saying that Erdman overruled this case, and that's simply not true. This is still good case law, and I might also add that Sandoval is in the Court of Appeals of Texas of Austin, and the case that I cited to you is the 14th Court of Appeals here in Houston, Texas.
Response?
Judge, nothing from defense. It is, from the state. It is really just something to consider for the court.
I'm ready to rule. I think it's totally coercive. Absolutely. I mean, there's just no, I've never seen something like it, statement that, so I'm going to get locked up regardless, right? If you do breathe and you blow under, I'll take you home. If you do blow over on breath, then you're getting locked up. All right, I'll blow. I mean, really. If you blow under, quote unquote, I'm taking you home. If you blow over, you're getting booked in. If you do blood, you're getting booked in regardless, because blood takes 3 weeks, a month to come back. Yeah, I think it's totally, yeah. All right, I'm going to grant your motion as far as the breath.
Thank you, Your Honor.
Okay.
And Your Honor, just to kind of maybe make this faster tomorrow, the state has also, we kind of touched on the motion in limine. And one of my motions in limine was to keep any testimony of the horizontal gaze and nystagmus, the eye test, out of evidence because it was improperly performed twice. Once, the HGN that was given might as well have stood for here goes nothing, because that's kind of what it looked like. And then the second time, the horizontal gaze nystagmus test was just murdered.
We agreed to leave it out already.
So, okay, but I just wanted to clear that up for the record.
So just, admonish
this
your
courtroom
officer.
session highlights Judge Fleischer's approach of combining accountability with clear guidance. Throughout the hearing, the judge repeatedly explains that defendants must understand the seriousness of their decisions and follow court conditions. Whether discussing driving offenses, bond requirements, or public safety concerns, the court focuses on preventing future problems while holding people responsible for their actions. The biggest takeaway from this hearing is that warnings from a bench are not empty statements. They are opportunities for defendants to make different choices before consequences become more severe. Judge Fleischer's message throughout the courtroom remains consistent. Follow the law, respect the conditions given, and take responsibility for your future. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.